Good afternoon. My name is Alena Shautsova. I am an immigration attorney from Brooklyn, New York. Today, in my Facebook presentation, I would like to address a very important issue of how the immigration system is going to work while we're all trying to save ourselves from coronavirus. You're probably aware that currently USCIS asylum offices and places that take your biometrics are temporarily closed through April 1st. Also, immigration courts are closed for all non-detained hearings, including individual hearings, through April 10th. ICE stated that they will not do the enforcement operations. Basically, they will not try to arrest people except for criminal situations. ICE reporting in person is suspended as well. But how are we going to move forward? What's going to happen after April 10 or after April 1st? How is going to unfold? Because I suspect that the situation is not going to be resolved within the next 2 weeks, right? So what's going to happen? Well, we already have clues as to what is going to happen. Today, I received an email from the Immigration Court Administration about the memorandum dated March 18th, 2020, where they're proposing new practices as to how the immigration court cases are going to be handled. Okay, it's very important. Basically, according to the new practices, the main immigration judge, let's say, right, the person who is setting up the rules, telling the practice rather than the rules, telling what other judges should do, suggests the following. As much or as many cases as possible are going to be heard via phone or via video conferencing where it's available. Then they're going further, saying that the judge, on consent of the parties, may waive the appearance of the respondent in court and have the immigration hearing without the person present. Written pleadings and written submissions are favored, and requests for in-person conferences to submit documents or resolve a legal question are disfavored. It means that we're going to enter times where most of the practice is going to be shifting to remote work, where we submit the documents and the judge is going to decide the question based on submissions, both from attorneys and from prosecutors. It means that if you do represent yourself, you better learn how to legally write. All right, so of course it's going to make it harder for people who are representing themselves to be effective in this situation. And you may not agree to this practice. You may want to come to court and talk to the judge. But the problem is that there are restrictions now as to who can come to court. And if the judge sees you are not feeling well, for example, they may take you out of the courtroom. That's what the memo also is saying, okay? So basically, they're proposing that written pleadings are answers to the notice to appear. The person would receive a call to appear in court where it's going to be saying something like that. You're not a citizen or national of the United States. You entered the country at this and this place at such and such date. Those are allegations and notice to appear. They're proposing that answers to those questions, very important answers, are going to be done in writing. To be fair, some judges already were asking them to be done in writing. You have to do them in writing every time when you file a motion to change venue as well, okay? But now that seems to be going a practice, at least for the time of the coronavirus situation. If there is a dispute over the allegation, the memo says parties will have to submit legal briefs, legal arguments, what and how this dispute is supposed to be decided, and the judge is going to rule on that. Another very important issue The judge may set deadlines to submit applications for relief by a certain deadline remotely. And if a person is not going to meet the deadline, the relief will be deemed waived. Means that the person waived the right for that. The person will not be able to assert that right later, and the judge may rule and even issue removal if the person has missed the deadline. Okay. Then the memo also says about stipulated orders. Imagine if the prosecutor and attorney are going to agree that the person is eligible for this or that relief. The judge will simply confirm that when both parties, the prosecutors, the government, and the attorney, are submitting a motion for that. So that's very important. It means that lawyers and prosecutors will have to start working together, basically, more often. It's already happening. I mean, it's not a totally new practice for the lawyers, because those who also practice in civil courts or general courts already have to cooperate. There are rules in place about that you have to talk about the case with your opponent, you have to go through discovery and things like that. But that's what we're going to see now in immigration courts happening as well. Basically, it's not going to be that when you need to file for adjustment of status application, you will be doing it when you see the judge. You're going to be moving into paper submission. So those of you who are going to be representing themselves, you have to read Immigration Court Practice Manual, because if your documents are not submitted the right way, they will be rejected. Okay, so that's what's going on right now. Those are the latest news about how the immigration court is going to operate during this time. We do not know yet what's going to happen with USCIS, because of course interviews are very important for them, and we're not going we do not know if the interview cannot be done in person for obvious reasons, what's going to happen. Perhaps also they will be implementing video conferencing, but I doubt that. We're going to see what's going to happen. Okay, so for now we have a couple of deadlines until the places are shut for April 10 for courts, April 1st for the USCIS and asylum interviews. I'm going to update you on new changes, what's going to happen. But basically, another very important point, currently USCIS deadlines are continue to run. So if you have to file a motion to reopen or appeal, you have to file it within the deadlines that you have, even though they suspended the in-person services like interviews and dropping off the papers. Okay, I can imagine that people who used to submit certain applications in person, like applications for deferred actions that can be submitted usually only in person, those people will not be able to do that at all unless we will receive some sort of guidelines from it. I think that the most damage are going to be for people who are applying for something like a special immigrant juvenile status, because right now a couple of courts basically don't get back to me in family courts as to what exactly going to happen with those hearings. Will these hearings qualify for guardianship proceedings that still supposedly should be going on or not? So this whole situation is very uncertain right now. I think in a couple of weeks we're going to have clear guidelines as to how those proceedings are going to be handled, perhaps also by the phone, okay, to avoid crowds, to avoid people to come in, maybe something like that, maybe not. It depends on the courtroom ability to capture the hearing. So this is all for now. I'm going to keep you posted, and thank you for watching.